Welcome to this panel discussion on the Supreme Court of Canada's recent decision in Ontario v. Restoule. I'm Kristen Boone. I'm the Susan and Perry DeLeese Dean at the Faculty of Law, the University of Ottawa. I'm extremely pleased to welcome you to this discussion about the decision that was handed down last month. This unanimous decision is already being called a landmark ruling. As Dean of the largest faculty in Canada with a deep commitment to truth and reconciliation with Indigenous nations, I am thrilled that we could bring together such an esteemed panel of experts to talk about this decision, two of whom were directly involved with seeing this matter through to justice. We at the University of Ottawa pay respect to the Algonquin people who were the guardians of this land. We acknowledge their longstanding relationship with the territory, which remains unceded. We pay respect to Indigenous peoples in this region from all nations across Canada who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. I'd like to begin by giving you a few facts of the case and then setting up the conversation for today. In 1850, the Anishinaabe who live in Northern Ontario along the banks of Lake Superior and Lake Huron entered into two treaties called the Robinson Treaties, by which they ceded over 100,000 square kilometers to the Crown in exchange for the continued exercise of inherent rights in that territory, like the rights to hunt and fish throughout the treaty territory. And in exchange, they received annuity payments in perpetuity. In the decision of Ontario v. Restoule, which the Supreme Court handed down last month, the court held that the Crown breached its promises to the beneficiaries of the Robinson-Huron treaties. Specifically, it failed to increase the annuities beyond $4 or 2 loonies to inhabitants after 1875, despite the inclusion of what's called an augmentation clause in the treaty. The decision, written by Justice Jamal, is direct in its condemnation of the Crown. It states that the Anishinaabe were left with an empty shell of a treaty promise, and further, that the Crown's conduct was a mockery of that promise. There are many themes that we could discuss today in this decision, but in the interest of time, we have decided to engage with three central topics. First, the role of ceremony and the trial court's engagement with Anishinaabe legal traditions. Second, the concept of the honor of the Crown and the duty of diligent implementation of treaty promises. And finally, we'll touch on the standard of review from lower court decisions and the question of what's next with regards to remedies of compensation. Of note is that the court stated that the Crown has 6 months to reach a settlement with the First Nations who are signatories to the Robinson Superior Treaty or determine a compensation amount. We have a wonderful panel here today. We have former Chief Duc Pelletier, the lawyer for the Robinson Huron Trust, David Nawigabo, and Professor Sophie Theriault, who's a specialist in sovereignty for Indigenous peoples. Before I begin, I would like to thank our U-Ottawa team for putting this panel together, in particular, Stephen Binman and Véronique Larose. Please note that this session is being recorded. If you have a question for our panelists, I encourage you to enter it in the Q&A function, and our speakers will take questions as they can during their presentations, and we have time set aside at the end for them to answer other questions as well. So let me begin by introducing our first speaker, Duc Pelletier, who is a proud Anishinaabe citizen and former chief of Wikwemkong unceded territory. He's a representative plaintiff of the Robinson-Huron Treaty Trust that brought forward this case. As chief, he oversaw all aspects of community development and public policy initiatives. His accomplishments include overseeing the ratification of the Wikwemkong Chi Nak'nigowin Constitution and the first Children's Bill of Rights on a First Nation in Canada. He has also been involved in partnerships that developed to support social infrastructure, investments, and residential healing lodge, an emergency shelter, and a 100-bed long-term home. Our second speaker will be the lead lawyer in the case, David Nawigabo. David is an Anishinaabe lawyer who founded the law firm of Nawigabo Corbière, which is located with the Chippewas of Rama First Nation. We are very proud that David is an esteemed alumni of our Faculty of Law here at the University of Ottawa and a member of our Honor Society. He has litigated and negotiated some of the most important Aboriginal law cases in Canada. He represented First Nations in land claims, title cases, and has appeared at courts at every level in the country. He was counsel at the Supreme Court for members of the Ojibwe Anishinaabe Nation who were beneficiaries of the Robinson-Huron Treaty of 1850. And he has been with this case since its inception, 17 years ago. Finally, we will hear from my colleague, Professor Sophie Thériault. Professor Thériault is a full professor and former vice dean in the Faculty of Law, Civil Law section. She holds a doctoral degree from Laval University, and she has been a visiting scholar at several universities in Canada and abroad. She served as law clerk to the Honorable Louis Lebel at the Supreme Court of Canada in 2002. Professor Thériault's research focuses on Indigenous peoples' rights in the context of natural resources and food security and sovereignty for Indigenous peoples. Let's get started. Chief, please tell us how this case arose and why it is so important to your community.
Thank you, Dean. Before I start, I'd like to introduce myself to the panel as well as the audience. Nigan Wasaganabit Gani Dijnakas Makwando Dem Nimki Beneshi Gibbon Atmak Nande Nishnave Ninendao. We Quam Kong Viven Java, me what again in Minakia. So good afternoon, everyone. My name is Duke Palche. I'm from Wequem-Coahuila Territory. And in relation to this conversation, I'm also a representative for the action that has proceeded through the courts. What this means for our community is an opportunity for specifically to rekindle the council fire, as well as renew the treaty relationship with the Crowns. I'm myself as a leader in my community, elected a number of years ago both as a council member and as the chief for 10 years. One of my missions was to seek out who was representing the Crown at every meetings that I had attended with the bureaucracies, both at the federal and provincial levels. There was always this concept of the Crown being someone or something that could never be seen. And it's through this process of entering into the courts that I could say that veil of who the Crown is was lifted to an extent. And it's been something special for all the 21 communities that have participated in this annuities case that have members and citizens that are party to the Robinson-Huron Treaty of 1850. It's been an opportunity for each one of the communities, as well as all their citizens, to, I will say, finally see some benefit from the relationship that our leaders in 1850 had envisioned. They, during the negotiations in 1850, much of the leaders had realized that development was going to be occurring in the territory. They knew that there was going to be a lot of infrastructure developed, and they had foresight to envision that they wanted to be participants in the economy, because during the time in the mid-1850s, early 1860s, there was already elements of exclusion of our people to continue participating in the economy, not only in trade relations, but also in very simple aspects of, in my community in particular, where we were supplying all the main transportation means and fuel to all the steamships that were traversing the Lake Huron area. At that time, there were no vehicles, there were no railroads, but it became the policy of the federal government and the Crown that our people were not able to continue to participate in any forms of economic activity. So this treaty itself, it contemplated our continued participation as well as attaining benefits from the treaty. As you noted, there was elements of retaining inherent rights and the ability to continue practicing those rights throughout the treaty territory in exchange for an annuity that would continue to benefit the collective environment that the treaty had put forward. So the nation that existed, the Ojibwe Nation, they had always envisioned to retain full benefits from any developments that were contained within a territory. So now we've taken it upon ourselves through a number of conversations over the years, highlighting the fact that many of our leaders right from 1851 had indicated to the Crown and requested that the treaty promise in 1850 that the Crown needed to augment and provide an annuity and an increased annuity. So they continue to come together on an annual basis and request either through petitions, letters, conversations within the council fire environment that the annuity needed to be increased because they've seen over the years many developments happening throughout the territory. And it was finally, I guess, through the good graces of Canada itself, who had no direct activity in relation to managing the lands and any of the proceeds from management of those lands. They increased the annuity in 1874. And it was Ontario that had continued to neglect its participation due to separation of powers that exists within the Constitution in 1867. So and in that, Section 91 and 92 clearly articulate the division of powers, where the federal government retained its responsibility for First Nations on a go-forward basis as a result of the Constitution being created. So we ourselves, under modern times and modern leadership, it's just recently that we've had the ability to retain legal counsel. Through Indian Act amendments in the 1950s, there was court cases that came about that allowed for Aboriginal title, as an example, to be confirmed that it was a concept that existed within the common law in 1973 and under the Calder decision. So these subsequent court decisions over time allowed for not only our people to be educated about what the law is, but also many of our own citizens to attain the education and qualifications to be able to represent ourselves. And a prime example is one of the other panelists here, David Nawagabo, and his partners who've brought this, and they're Anishinaabe lawyers who are members and beneficiaries of the Robinson-Huron Treaty itself. So we're in a time in our history that we're able to advocate for ourselves using the systems that and the tools that our ancestors, the leadership of 1850, had left for us. And the way that the legal environment is now is that we have those abilities to come together in a unified process. And I can point directly to the unification of 21 First Nation communities and their leaders in being able to bring this case forward 17 years ago, as well as sticking together throughout this whole process to finally allow each of our communities and each of our citizens to attain significant benefits through not only with the assistance of the courts, but through a negotiation process with the Crown representatives. So it is a very exciting time for many of our communities, because now they have the ability to look to the treaty, but also look towards the future on what the council fire and rekindling that relationship with the Crown could be.
Thanks very much, Duke. Can I just ask you a follow-up question? At the trial court level, is there anything about the ceremony or the incorporation of Indigenous legal traditions that's worth commenting on for our audience today?
Well, one of the things that are at the very onset of developing the court case, the legal team were very clear that they required Anishinaabe law, our concepts and principles, to be not placed into the court, but presented before the court, so that there's an understanding within the common law system that there's equal and parallel systems that allow for the governance of our communities to be able to function. So one of the things that are the elders that have been advising the legal team as well as the leaders throughout this process, they were very clear and articulate that our Anishinaabe laws and customs, traditions needed to be put into the court and alongside the court process to allow for a complete and greater understanding that we are a people, that we're a nation, we have our own language, we have our own customs, and we have our own ceremonies. So it was very reassuring that right from the very onset of the night before the actual hearings and opening statements, that there was officials from both levels of the Crown as well as from within the justice system itself, the court, that participated in ceremony. And that has been the one of our hopes, is that they would understand, they would participate. And it's been very clear that many of the tools that the Creator has given to us as Anishinaabe people were clearly understood and respected by the court through the decision in the trial decision in stage 1.
Thanks very much. And you had talked about different Indigenous communities that came together in this effort, and I just wanted to note that that there were 20 interveners in the case before the Supreme Court, which is a large number. So it's very interesting to see the the level of interest and the allegiance that was formed. So let me turn to David now. David, you were involved right from the beginning in this case, 17 years, as we said at the outset. What were your key wins at the Supreme Court of Canada level, and what can you tell us about the process of your 3 different levels of court that would be of significance?
Yes. Before that, I just want to introduce myself. My Anishinaabe name is Gijiganung, which means day star, and I'm with the Wolf Clan, Maingun Ndodeb, and I'm from one of the First Nation communities within the treaty territory called Wiwaskinaga, and as you noted, I'm also a former graduate from the University of Ottawa Law Faculty. I hate to mention how long ago I did graduate, but I will. It's 1980. Probably many of the people weren't even born yet, and so I've been around for a little while, and I was very fortunate to be involved in the Restoule case right from the outset. It allowed us to engage, to formulate the evidence, to formulate the approaches right through to the Supreme Court of Canada. And I guess before I get underway, I do want to acknowledge the support that we received from the leadership and from the communities, particularly also from the elders. The elders were a very big part of this case. And you mentioned the importance of ceremony, and I will get to some aspects of what the court has said about that. But just as a lead up to that, I do want to mention that it was pretty clear to us in the instructions from the leadership and from the elders that Anishinaabe ceremony and Anishinaabe law had to be a big part of the case. It was important that the Anishinaabe perspective was understood of course, the case was about interpreting a treaty, interpreting a particular clause in the treaty, and it was important to understand the Anishinaabe perspective. And because we don't have any Anishinaabe people that were present at the treaty signing, and because we have really very minimal records of the treaty proceedings, just the treaty itself, the diary from Robinson and his report, there was no record of the Anishinaabe understandings. There were notes taken of the speeches made by the Anishinaabe leadership at the Treaty Council in 1850, but those had been lost by the Crown. So it was really important that, to the extent possible, and to the extent that Anishinaabe Mwin, the language, Anishinaabe Adzuwin, the culture, and Anishinaabe Anakanagewin, the laws, were brought forward to sort of fill in that context, so that people had a sense of what would the Anishinaabe have understood was the intention behind the treaty in 1850. So that was important. The trial process itself was a really embracing of Anishinaabe culture, ceremonies. And one point I will mention, I'm not going to go into the standard of review, but one of the important points that Justice Jamal made in the reasons for judgment was the high degree of deference that was given to the trial judge. And the rationale for that was the extent to which she engaged and embraced the Anishinaabe community, including participation in ceremonies and taking the court out into the communities. And I just want to mention this because I know that Anishinaabe or Indigenous ceremonies have been working their way into the court process. And a lot of times it's kind of as a very small measure and very reluctantly by some trial judges. The use of a eagle feather, for example, in affirming. Sometimes a smudge, but those were always before the trial itself opened. One of the things about this case, and it's mentioned, actually those ceremonies were part of the trial process, a formal part of the trial process. And the fact that the Supreme Court of Canada in its reasons acknowledged that and said, as a result of that, the findings of fact, the historical facts and the facts related to the Anishinaabe perspective were so important. I certainly see that at the very least as a tacit endorsement of that approach, so that trial judges should not be reticent or reluctant about embracing Anishinaabe law in their courtrooms and ceremonies. One of the big differences in this case, not only was ceremony brought into the courtroom, but the judge, well, actually the Anishinaabe invited the judge and the Crown Counsel to participate in ceremonies, in sweat lodge ceremonies, as Mr. Pelche has alluded to. So there was what are called sweat lodge ceremonies that were engaged in, run by the knowledge keepers who presided on the Anishinaabe side. And as long as both crowns participated, the judge felt comfortable participating in sweat lodge ceremonies. And that's all a part of the importance of embracing and obtaining an understanding, making the process less adversarial. Of course, there were adversarial moments in the trial, but generally speaking, less adversarial because of the extent to which the Anishinaabe participated with the judge and the crowns in in the process. Also want to mention Nishnabemwin. It was important for the leaders, and they emphasized this at the outset, that, I mean, it's not just the treaty text. And I will point out, Dean, that you mentioned at the outset that a certain amount of land was ceded, but the Anishinaabe understanding is that the lands were not ceded and surrendered. They agreed to share the land. In fact, I mean, the court, neither the trial court or the Court of Appeal or the Supreme Court of Canada made a ruling on that issue, but it was an issue that was discussed. Our elder witness, Elder Rita Corbier, made a point of saying, well, we don't really have a word for cede, release, and surrender. And she explained what the Anishinaabe word was, and it wasn't that. I mean, in the end, it wasn't pivotal for the outcome of the case, but it's an important point to mention, because we do have two different systems who are of law and culture who are entering into a treaty in 1850, and they have completely different understandings. It's not, I mean, we can't really take the present day context and you know, transpose that back into 1850. The understanding, the culture, the mentality in 1850, according to that, the Anishinaabe would never have sold their mother. And there's no word in the Anishinaabe to express that complete and utter, you know, cede, release, and surrender. So it's an important point. Another point, and this was kind of a central, it is a central issue in the trial, the issue of discretion. Of course, Ontario's insisted that the Crown has had the discretion, and it was an important point all the way through. And so one of the key witnesses about the Anishinaabe interpretation of Her Majesty graciously pleases, which is what the augmentation clause says, that the annuity will be set at a certain amount, and it will be increased up to £1 or $4 if production allows the Crown to do so without incurring loss, or such further sums as Her Majesty may graciously be pleased to order. And so there was a discussion, and it's central to the reasons, about what could that have been expressed? How could that have been expressed in the Anishinaabe? And they turned again to the testimony of Rita Corbier, Elder Rita Corbier. And the court interpreted her understanding or her interpretation of that as, well, it did mean discretion, but not unfettered discretion, which is what the Crown's, the Ontario Crown was insisting. Her Majesty graciously pleases meant, and it was clear that that's not what was intended. But more importantly, Elder Rita Corbier talked about that clause in terms of the Anishinaabe perspective. How would the Anishinaabe have seen that clause in the context of their leaders, this great mother, the great mother in a parental role and a very caring and generous role? And so the trial court and the Supreme Court of Canada adopted the understanding that a leader in that position would never have been arbitrary about increasing. And so Her Majesty graciously pleases, although it implied a sense of discretion, it would not have meant arbitrary discretion. Moreover, it would have been imbued with notions of Anishinaabe law and values, including the 7 teachings of the Anishinaabe, of the 7 sacred laws, including love, respect, humility, honesty, and truth. And so Rita Corbier talked about this in terms of the heart teachings, because one of those sacred teachings is about truth, which in our language is de bwe win. And the word originates, or the root of that is ade, which means the heart. So when she talked about, what Her Majesty graciously pleases meant, it had to mean something that was coming from the heart, and that the Anishinaabe would never have understood that the crown intended to be mean-spirited or not speaking to that subject as coming from the heart. And she called those the heart teachings. So that's what that's some of the testimony. I would have liked to have spoken about the go forward aspect, but I will ask, because that I should mention in terms of that issue of discretion, while the Supreme Court of Canada said that the issue of discretion and her understanding of discretion, the interpretation of the augmentation clause didn't ultimately turn on the issue of discretion. For us going forward, the issue of discretion and the understanding of discretion as sort of encased or imbued, or certainly including the Anishinaabe understandings of discretion, will have important implications going forward. So anyway, I know we're gonna I could have said more, but I know we'll
that's
probably run out of
terrific.
time.
That's fine, and we will definitely come back for some of the go forward conversation. I just wanted to flag two questions that have come through in the Q&A, David, just to see whether this is an appropriate thing for you to comment on. One attendee asked what your impressions were of how well Crown lawyers understand the Crown Indigenous relationship, including the intent of treaty signatories. And then there was a second question here with regards to the panel's opinion on the relevance of the Restoule decision for treaties that don't have augmentation clauses. I just wanted to invite you to comment on those questions if appropriate.
Well, on the first one, it was incremental. Certainly when the case started, the views as reflected in the pleadings was a total non-understanding on the part of the Crown lawyers. The typical adversarial initial reaction is, no, we don't negotiate in treaty interpretation. And the clause, the Her Majesty graciously pleases clause, was understood as being absolute discretion on the part of the Crown. That's why they never did increase the annuity. They didn't take the time and to understand the Anishinaabe perspective. Perhaps they understand it better now with the Supreme Court of Canada decision, but it was incremental. As we went through the trial process, as we engaged in feasts and in ceremony together, it became more we came closer to a meeting of minds. And in the end, the Crown and Right of Canada didn't appeal the trial, didn't appeal to the Supreme Court of Canada. And so that's reflective of something. Ontario continued to appeal, but even Ontario moved a great deal throughout the trial and appeal processes in the various stages. Does the case have some bearing in other cases? Well, for certainly on the issue of remedies, it was unclear, and I know that Professor Sophie is going to be discussing the issue of remedies, so I won't go too far into it. But that is an important point, that breaches of treaty give rise to the full range of remedies, including coercive remedies and remedies of compensation according to the Supreme Court of Canada. So that's just one bit. Thank you.
Thank you very much. Okay, I'm delighted to pass the floor now to Professor Sophie Thériault. Sophie, you're an expert in constitutional law, Indigenous legal traditions. Can you please tell us what you find particularly significant about this decision?
Thank you. Thank you very much, Dean Boone. I'm truly delighted and honored to be here today to discuss the Restoule decision, which is certainly one of the most significant treaty decisions to come out of the Supreme Court of Canada, at least, I would say, since the Marshall case. This decision is a major victory for the Anishinaabe communities that are parties to the Robinson Treaties. In a unanimous decision, the court held that the augmentation clause in the Robinson Treaties requires the Crown to periodically consider whether it can increase the annuities without incurring a loss, and if so, whether to proceed and by how much. The court also affirmed that the Crown discretion under the augmentation clause is not unfettered, as it must be exercised honorably and in a manner that upholds Anishinaabe values and principles, subject to judicial review. The court was also clear and assertive in holding the Crown accountable for failing to honor its treaty promises, and clearly affirmed that breaches of the duty to diligent implementation, which in this case amounted to a breach of the treaties themselves, can result in truly consequential judicial remedies. So this decision is significant in many ways, and that I've yet, I must admit, to fully explore. So in the minutes that I have, I will highlight some of my preliminary thoughts on two aspects of the decision that I find particularly significant. One that was already touched on, which is the role of Anishinaabe law and legal perspective in the interpretation of the treaties, as well as in the design of the remedies, which I argue has the potential to breathe life to the treaty relationship. And secondly, the robust application in the Supreme Court decision of the honor of the Crown principle and the related duty of diligent implementation, which has led to consequential remedies in this case. So as Anishinaabe legal scholar John Burroughs has written, treaties can be thought of as creating an intersocietal framework in which Indigenous law intermingles with state law to foster peace and order across communities. Treaty relationships should therefore be defined and renewed both from an Indigenous law perspective and a state law perspective. I should emphasize at the outset, and it's quite an important nuance, that the Anishinaabe plaintiffs in the Restoule case did not ask the court to apply Anishinaabe law and legal principles. Rather, they asked the court to consider the case within the framework of treaty interpretation developed under state law. More precisely, the plaintiffs asked the trial judge to consider Anishinaabe law as part of the Anishinaabe perspective that informs the common intention analysis, rather than as a direct source of law prescribing a given solution to the litigation. Nevertheless, Anishinaabe law and legal perspectives were central to the proceedings and decisions at various stages of procedure, which is certainly one of the most remarkable aspects of this case. At the trial level, and David Nawagabo already discussed that, but I feel it's an important part of the decision, and I might discuss it briefly. Justice Hennessy provided a very detailed description of the historical, cultural, linguistic, and political context of the Robinson Treaties, as well as of the Anishinaabe law and legal perspective that informed the Anishinaabe understanding of the treaties, based on extensive testimony from Anishinaabe elders and other knowledge holders, as well as on an impressive collection of primary and secondary documentary evidence. In interpreting the treaty, the judge drew extensively on the Anishinaabe principle of respect for the Anishinaabe jurisdiction and their authority to conclude agreements to share their territory, of responsibility to ensure that Anishinaabe people could continue to depend on the land for sustenance, shelter, medicines, and spiritual well-being, of reciprocity, meaning that a gift would attract a reciprocal gift of commensurate value based on the idea of mutual interdependence, and of renewal, invoking the idea that the relationships are ongoing and must be renewed continually. The judge also referred extensively to the long history of the treaty relationship between the Anishinaabe and the Crown, grounded in the covenant chain alliance, symbolized by a ship tied to a tree with an iron chain, representing the interdependence of Anishinaabe and the Crown, and reproduced through a process requiring the constant renewal of the relationship. Perhaps more remarkably, as David Nwegebo emphasized, Anishinaabe law was enacted throughout the trial process in the forms of Anishinaabe protocols and ceremonies that were also present when and way long before the Robinson Treaties were signed in 1850s. So, for instance, proceedings were held in different Anishinaabe communities on the treaty territories, facilitating testimonies by elder and providing a land-based experience to the court. Ceremonies took place on the territory as well as within the courtroom, with the people participating in the trial and community members engaging together in different ceremonies and protocol. The trial judge findings on pertaining to Anishinaabe law and legal perspectives were not questioned by the Court of Appeal and found their way into the Supreme Court decision. So importantly, in this regard, the court held at the outset that while the interpretation of a historic treaty is reviewable for correctness, factual findings are entitled to deference and are reviewable only for palpable and overriding errors. So this differential standard applied to the trial judge extensive findings on Anishinaabe law and legal perspective, as David mentioned earlier. However, even if historical findings and legal facts regarding Indigenous laws do not, according to the court, determine the issue of treaty interpretation, these findings were highly relevant to the Supreme Court interpretation of the treaties, to its understanding of the honor of the Crown and related duty, as well as to the design of the remedies. So throughout the decision of the Supreme Court, the court refers to the Anishinaabe system of law and governance and its underlying principle of respect, responsibility, reciprocity, and renewal. The court also refers at different places to the Covenant Chain Alliance, which informed and continue to inform Anishinaabe perspective on the treaty. The court, for example, affirmed that by failing to implement the augmentation clause for 150 years, Canada and Ontario also failed to uphold both the honor of the Crown and the principles of respect, responsibility, reciprocity, and renewal that underpin the Anishinaabe perspective on the treaty relationship with the Crown. With regard to remedies, in requiring honorable and meaningful negotiations with the Anishinaabe over past breaches, but also looking to the future of the treaty relationship, the Crown emphasized in several places the relational rather than transactional aspect of the treaty making and the importance of encouraging the renewal of the treaty relationship moving forward. In sum, while the Restoule decision does not directly make Anishinaabe law enforceable as hard law, the court meaningful consideration of Anishinaabe law in this case has had tangible consequences for the state legal system and is likely to continue to do so through the future implementation of the treaty. So, of course, let's not be naive. Moving forward, the quality of the Robinson Treaties relationships will depend heavily on the Crown's readiness to return to the council fire and rekindle the perpetual relationship that the Robinson Treaties envision, as worded by Justice Jamal. In the meantime, however, the Restoule decision provides a clear roadmap for fulfilling the promises made in the treaties, both in terms of past breaches and future implementation. So this roadmap, and I'll be quite quick here, was drawn up by the Supreme Court on the basis of a particularly robust application of the honor of the Crown and the duty of diligent implementation that flows from it. So in short, while all parties agreed that the honor of the Crown must guide the interpretation and application of the augmentation clause and the appropriate remedies for past breaches, the parties disagreed as to the nature and intensity of the specific duties arising from the honor of the Crown in the circumstances of this case. Siding with Canada and Ontario, the court held that no fiduciary duties, ad hoc or sui generis, I'm not getting into that, arose in this case. However, referring to the majority decision in Manitoba Métis and to some lower court decisions rendered since then, the court found that the Crown has a duty to diligently implement or fulfill the treaty promises under the augmentation clause, a duty that attracts both procedural and substantive obligations. The specific obligations attached to the duty of diligent implementation are those that are required in the circumstances to maintain the honor of the Crown and to effect reconciliation. In this case, affirming in strong case, and I quote here, that for well over a century, the Crown has shown itself to be a patently unreliable and untrustworthy treaty partner in relation to the augmentation promise. The court held that the Crown had dishonorably breached the Robinson treaties by failing to diligently fulfill the augmentation clause and was therefore obliged to determine an amount of honorable compensation for past breaches. The court also provided, in addition to a declaratory relief, detailed future directions for the Crown to fulfill honorably and meaningfully its duties under the treaty, including a narrow time-bound negotiation with the beneficiaries of the Robinson Superior Treaty, after which, failing a settlement, the Crown will be required to honorably exercise its discretion and determine an honorable compensation for past breaches, subject to judicial review. In sum, although the Supreme Court held that fiduciary duties arise only in specific and somewhat narrow circumstances, thus reaffirming its previous judgment in Williams Lake and Manitoba Métis, the Restoule decision clearly confirms that the honor of the Crown can give rise to a duty of diligent implementation, attracting procedural and substantive obligations and subject to consequential remedies, which should guide the Crown in fulfilling its treaty promise. So I want to conclude very quickly on a just more personal note. The Supreme Court released the Restoule decision coincided with the end of the course on the Innu law order that I teach, or perhaps more accurately, I should say that I coordinate in Ouachat, Sept-Îles, a course long taught by my colleague Jean-Paul Lacasse that I would like to acknowledge here. This course is one of a growing number of courses, programs, and other field-based experiences offered by law schools across the country that contribute to the fulfillment of the Truth and Reconciliation Commission of Canada call to Action 28. Students enroll in my Innu legal order field course this year and in previous year received teaching from Innu elders and other Innu knowledge holders, were extensively exposed to Innu Emun, the Innu language, and witnessed and at times participated in ceremonies and protocol. They were also blessed with tasting traditional foods. Throughout the course, the students were immersed in different pedagogies for learning about law, developed a deeper understanding of the law in an Innu context, and became more aware of their responsibilities as law students and as future professionals to promote transformative reconciliation and make space for Indigenous legal orders. As great and enriching that this experience was, of course, this course is a very small step in the long life hard work needed for a legal professional to engage meaningfully and respectfully with Indigenous law. But nevertheless, I believe that those who participated in the course this year and in the past, including myself, are better prepared to undertake this task. So I just finished by saying that the Restoule case, as it unfolded from the trial level to the Supreme Court decision, is yet another reminder to law schools across the country of the importance of continuing the essential work of advancing Indigenous legal education and of welcoming and training an always increasing number of future Indigenous legal professional in the future. Thank you.
Thank you very much, Professor Thériault. We've got some interesting questions coming through from participants, and I just wanted to invite the panelists to respond to these. I will group them according to subject matter. One is, are there implications for the implementation of UNDRIP, the UN Declaration on the Rights of Indigenous Peoples? And another one involves treaty interpretation, and specifically in international laws, there's certain principles by which treaties are interpreted. And the question is there an analogous concept here in Canadian law? Does the Restoule decision create a new kind of canon of interpretation in accordance with Indigenous legal principles? Would any of the panelists like to answer those questions? Sophie, can I pass the floor to you first?
Yeah, with the UNDRIP question, in fact, it's following recent Supreme Court decisions. We could wonder why it was not mentioned at all by the Supreme Court of Canada. It was mentioned quite extensively in some recent decision, including in the decision on children, youth, and families of First Nations, Inuit, and Métis. And certainly, UNDRIP has provisions regarding treaty implementations and obligations of states regarding treaty implementation. For sure, with the Canada has a statute now mandating the implementation of the declaration in domestic law. BC has a similar statute. Ontario, unfortunately, does not, but certainly I would say that the declaration, even if not mentioned in the Supreme Court decision here, should be a guide also in the Crown implementation of its treaty promises in the Robinson treaties, but also in other historic and modern treaties for that. As for treaty interpretation as a precedent, I mean, the principles applied by the court for the treaty interpretation in that case are quite well known. It is the framework elaborated in the Marshall case, and the court cites integrally Justice McLaughlin's dissent opinion, but that was unanimous on this point, iterating very clearly treaty interpretation principle. And one of the main treaty interpretation principle is that of the common, seeking the common intention of the parties at the moment the treaty was negotiated. So all that is very well known law. However, I would say that the engagement of the trial court, but also to the Supreme Court with Anishinaabe law and legal perspectives and principles, and the way Anishinaabe law came to infuse the decision of the Supreme Court, both at the level of treaty interpretation, but also in its understanding of state law, and the way it defined the obligations arising from the honor of the Crown in this case, and the way it devised a remedy in order to also provide for principles such as renewal to occur in the future, shows that, like, for me, it's quite a unique way, quite a unique engagement with Indigenous law. That's still one of the exemplary ones. I don't know if, David, you agree or disagree, or if you want to comment more.
Yeah, I agree fully with you, Sophie. It's yeah, there certainly were submissions about the UN declaration in the if not the interveners, certainly the main parties dealt with the issue. I guess the Supreme Court of Canada didn't feel they needed to go there because in some ways it was helpful that they relied on principles such as honor of the Crown, and wound up elaborating on those principles without having to deal with international law, which tends to be the tendency of the courts not to have to go there if they don't have to go there to deal with international law. Having said that, will it contribute to the evolution of the application of UNDRIP within the country? I think it certainly, what the court said about the augmentation promise and the interpretation of the treaties is consistent with I would say the UN declaration. However, there hasn't been in Canada, and certainly not in Ontario, much in the way of policy consideration of treaties and treaty interpretation. And in fact, the initial reaction of Canada to negotiating this, claim was, we don't negotiate treaty interpretation, which is significant. They tend to not take an expansive view of the treaties and just don't even want to consider the perspectives of First Nation treaty parties to the treaty. Been a long-standing kind of vast gulf between the perspective of Indigenous, of actually First Nations people on how their treaties are interpreted and those of the Crown. And hopefully this case will contribute to maybe a dialogue, a discussion about, trying to bridge that gap. The second question, what was the second question?
It involved questions of whether or not there's like a canon of rules now about interpreting treaties in Canadian law.
Oh, okay, yeah. Well, I agree with Professor Theriault on that. It's certainly the rules, the canons of construction, the liberal interpretive principles are well known, including that treaties need to be interpreted in the context. They went a little further in this case, and maybe it's just an elaboration of that principle of understanding from the context, the application of Anishinaabe legal principles is certainly a significant, maybe not a departure, but certainly a substantive elaboration of that general principle.
Terrific. So I know that we want to talk about the go forwards in this case. What happens next? What are the remedies? Chief, I wonder if I could pass the floor back to you just to talk a little bit about what's important for your community at this stage in the game. And one of the questions that came up that I invite you to answer if appropriate is whether or not the adversarial model makes sense in this context. The participant said, should we be looking at litigating Indigenous Crown matters from the place of reconciliation and negotiation and problem solving? And I just wonder if you have any reflections on that as you take on the question of what comes next for you and your community.
Well, I think right at the very onset, we've had a number of conflicting opinions, I guess, on what is the best approach to address the treaty and the augmentation promise. And one of the things that was realized by a lot of the leadership back when the case was being developed was that they've taken approaches to look at international law. They've, in fact, they did during the repatriation of the Constitution in the early 80s, the chiefs sent a delegation to go and meet with the Crown, the British Crown and the Queen, and they could not attain an audience other than a couple representatives from the House of Lords. And from that, they understood that international law or securing some support on the international level, especially from the British Crown, wasn't going to be attainable. And one of the remedies the only remedies that was available, or their only option, was to actually bring this matter into the court. And it took a long time to develop the case. And I think even to just within the last year, during the Supreme Court hearing, the opening statement by the Ontario's lawyer and representative, they had indicated to the Supreme Court judges that they were seeking to have the court declare that they had discretion And immediately, there was a few of the Supreme Court justices, they jumped on that statement before he even had a chance to finish that, and stopped and asked how that has worked out for the last 150 years for the Anishinaabe peoples. So I think that was clearly an indication right at the onset of the Supreme Court hearing, is that we were on the verge of a large win before the Supreme Court, a large win confirming what our leadership, our elders, and our ancestors had always believed, is that there was an obligation by the Crown to increase the annuity. So now that the Supreme Court sided with the Anishinaabe perspective, or the Anishinaabe peoples, both in the Robinson, Huron, and Superior regions, the Crown now, as we've been discussing, they have that real responsibility to renew the council fire, to begin those discussions on allowing for our leadership to have very concerted dialogue with the Crown to ensure that our people and our community's needs are met based upon what was provided to ensure development within Northern Ontario. And I think that some of the things that I've continued to share in different forums is that it has been our people that has been carrying the burden of treaty. It was never part of the bargain that was agreed to. It was always about sharing the land. It was about sharing the resources and having reciprocal benefits as a result of entering into a relationship together. So we can look towards internally within the 21 communities to begin having the discussion on what that council fire means, as well as articulating amongst ourselves how we can bring forward much of our community's common interests before the Crown. So I think there's going to be a little bit of work yet that has to happen, but I think for the major obstacle right now is convincing both levels of the Crown, provincial and federal governments, that they have a responsibility to renew the relationship and sit down and have meaningful dialogue around a council fire.
Terrific. Thank you very much. David, could I pass the floor to you? Very interested in what your sense of the go forwards are as an advocate and an Anishinaabe lawyer.
It's interesting. I wholeheartedly agree with Duke, of course, and he mentioned the importance of this thing to Canadians generally, and it was important in the negotiations which resulted in the compensation settlement agreement, the past compensation settlement agreement, that the local municipalities supported the negotiation of the settlement agreement between the Crown and the Anishinaabe. But I'll refer you to paragraph 113 of the reasons for judgment, where the court says, yet the future-oriented significance of historic treaties is only one element of their precedential character. I think here that Justice Jamal is talking about the standard of review issue. And he goes on, historic Crown Indigenous treaties are binding not only on their direct signatories, they are binding on all Canadians, emphasized, who, because of the Crown's assertion of sovereignty, are also effectively implicated in these founding agreements. A treaty is a compact, not only among provinces or founding peoples, but also between non-Aboriginal population and Aboriginal people. So, it's important. I think that is an important reminder to the governments that we have to deal with, who represent people who are bound by these treaties, that they need to move forward in sort of renewing the relationship. Duke referred to the concept of council fire. That was a big part of the relationship pre-treaty in 1850. It was part of the covenant chain that the crowns would meet periodically with First Nations to renew the covenant chain relationship, to attend in council fire, to discuss the relationship and going forward. And so what's necessary in this context with regard to the augmentation promise is to meet, whether it's annually or certainly periodically, to discuss the respective needs of the parties. You know, what the Supreme Court of Canada called a permanent relationship. That's what's required for the renewal. Thank you. Miguel.
Thanks very much. There's a question in the Q&A as well about fiduciary obligation and you know what the importance of that was in the argument and whether a finding of liability would have changed the remedies in this situation. Is that something that you'd like to comment on, David?
Can you hear me?
Yes.
Okay. Well, the fiduciary duty, certainly that was part, we brought a cross appeal on that issue and it was important, but the reason why we brought it is we wanted to make sure that we had a remedy. And at the time it was unclear that we would get a remedy of compensation without relying on the fiduciary obligation. So really, the court, the Supreme Court of Canada, basically their approach was there's an ample range of remedies available as part of the honor of the crown. There's no need to resort to the fiduciary duty. So it didn't make a difference really in the outcome, I would say.
Thank you. Professor Thériault, what would you like to comment on with regards to the go forward? You know, as an academic and a scholar, where do you think the next horizons will be as we look at Supreme Court jurisprudence on these treaties?
Well, as I said, I think the court drew a pretty clear roadmap in this case, but a roadmap that could inspire future roadmaps, perhaps even in other treaties. And this roadmap includes looking at, in this case, Anishinaabe laws and legal perspectives in moving forward and in renewing the treaty relationship in the future. So I would say looking forward, I mean, it hinges in part, as I said, also on the readiness of the government and of like the people who will engage in those relationships to rekindle the council fire, as Duke Pelletier mentioned, and to enter in these relationships meaningfully, honorably, in good faith, and with the intention of maintaining those relationships perpetually, right? So a lot will rest on how the government will understand this roadmap and will take the good, like the route that the court is showing there. But I think it has important precedential value both in this treaty case and in potentially other treaty case. And the Crown could be reminded of the words of Justice Jamal that are pretty strong in moving forward in its treaty relationships. And as I said, it could breathe a new life, in fact, to treaty relationship if the Crown is to understand the words of the court as referring also to the importance of moving forward, learning and respecting Indigenous laws and Indigenous perspectives in renewing the relationship. As to how it will happen, or if we are hopeful it will happen, it would be more for Duke Pelletier and David Nwagabo to comment. I cannot, but I hope we can be. I hope we can be hopeful. And regarding the fiduciary duties, I fully agree with David. And it was interesting because reading the decision, when I got to this part of the judgment, and I saw Justice Jamal determining that there's no fiduciary duties, and we can say that it's not really new. It was not necessarily surprising. The court is not is basing itself on Williams Lake case and on Manitoba Métis case. So I was not necessarily surprised by what they were saying, but I was a bit disenchanting at this point of the judgment. And then reading about the duty of diligent implementation flowing from the honor of the crown and the remedies it led to, right, which are both procedural and substantive and quite considerable. I don't think it affected the outcome in this case, and we'll see how this duty plays out in future cases where there cannot be, where there is no fiduciary duties, but where Indigenous communities can expect from the Crown to fulfill diligently its treaty promises and may be subject to considerable, consequential remedies if it does not do so, based on the honor of the Crown and the duty of diligent implementation and not on the fiduciary duty.
Thank you. We're just about at the end of time, but I just wanted to invite David to comment on one final thing, if he wishes. One question that came through is, who should be leading the negotiations from the Crown Canada as the treaty partner, or Ontario as the primary regulator of Crown lands? You know, could Justice Duhamel have given us some guidance on that question in the decision? And I wondered whether that was something you'd like to respond to.
Yeah, that's I think that's probably better put to the Crowns. Certainly, you know, there is one Crown. We have divided jurisdiction in Canada, and they need to come to terms on how to fulfill that. There are clearly obligations on the part of both, and it's a source. And this was one of the comments by the Court of Appeal. It was itself an impediment to the ability to negotiate a settlement, because the Crowns couldn't agree. Well, who was responsible? It goes back a long ways, of course, to the annuities case back in the 1800s. But they do need to come to terms with it, and you know, if they want my help and advice on it, I could probably provide it. But I think it's better for them to answer that, and they should answer it soon. And they should answer it in a meaningful way that contributes to the meaningful implication or application or implementation of that treaty promise going forward.
Terrific. Well, thank you very much to our panelists for being here today. Thank you for participants for joining us on this Tuesday afternoon. I hope you found today's presentations as informative and stimulating as I did. Please continue to check the faculty's website for other learning opportunities and programming with regards to developments in Indigenous law. Miigwech, thank you very much, and be well.
Thank
you. Miigwech. Pamapi.